Good morning, everybody. This is John Parsons. Before we start, I just wanted to take a couple minutes to reconnect. First of all, there's close to 150 people that are already logged on this morning, so that's great to see everybody online and ready to go. Before we start, I just wanted to take a moment to talk about what we've gone through the last couple months collectively, and begin by commending board staff and members for the efforts that have taken place during this period. The performance of retirement boards and administrators during this period has been phenomenal. The positive cooperative interaction that we've had with boards during this time has been positive. It's been successful. And it's really been if there's a silver lining here, the amount of effort and that has gone into making this work, both the interaction with PERAC and the boards, and the interaction between the boards and the municipalities and members has been extraordinary. So I want to commend everybody for that. Thank you for the response that we have had to boards, and for the thank yous that we've received for our memos and our efforts to try to get everybody through this, including ourselves. As you know, there's no playbook for this, but as far as I'm concerned, we're all in the same situation. I think everyone appreciates the challenges that PERAC faces and the boards face, and recognizes we're all in this together, and we're here to try to help you to get through this difficult time. And hopefully in a couple months, we'll be back to seeing each other and being able to deal in a relatively normal manner. So like I said, we appreciate there are a number of challenges that we've faced. The biggest is that many of the things that we do and that we expect of you are legal requirements. They're in the statute. And as much as we would like to be able to waive certain requirements, and you would like us to be able to waive certain requirements, at least during this period, we don't have the ability to do that. So when we have put out memos, we've tried to provide the best guidance that we can based on our ability to guide you and to provide alternatives to the current statutory requirements. The other challenge that we have, just like you, is a number of these things are out of our control. Office buildings are closed. We're working remotely. Medical examinations are not being held in office. So that's, as you know, if you have followed our memos, that is a process that we have been trying to move off to a remote process. And I'm happy to tell you, and Kate's going to talk about that later, that is up and running through extraordinary efforts by Kate and our physicians and our vendors. And lastly, our municipal budgets. We'll be talking about that later, but we all know that how difficult that has been to be able to answer questions about what's coming down the line when none of us really know. So from a protocol standpoint, please remain on mute. On the right-hand corner of your screen is a chat feature. If you have questions, please submit them through the chat feature. If you're concerned about receiving board credit, if you're a board member and want to receive credit, there's a list of attendees on the right-hand side. If you've logged in on your computer, you should see your name on that list. If not, please send an email to Natasha at our office, so we'll make sure that you receive credit for participating today. So at the end of each speaker, we will try to address the questions that come in during that time rather than trying to save them all for the end. And the only other thing I would say, if you have individual questions that are unique to your board about a particular member or a particular situation, that this really is not the forum for that. We're trying to address questions that apply to all or at least some retirement boards. And the other thing I would note is this is not a comprehensive educational seminar, as we often do. The topics we're going to cover today are in the context of just trying to get through this situation. And many of the things that we're talking about today, hopefully we won't be doing or having to do in that way in a couple months. So with that said, I'm going to take my beautiful picture off the screen, and Katie Brady and Judy Corrigan from the legal staff are going to talk about signatures and how to deal with signatures during this situation. Thank you.
Good morning, everyone. As John mentioned, today Judith and I will be talking all about signatures. Our presentation is going to provide you with an overview about how boards should deal with the requirements of obtaining signatures, both board member signatures and member signatures during this unprecedented time. Next slide, please. So how the boards do business. Even though boards are no longer meeting in person right now, boards must be able to complete their essential duties, and some of which require board member signatures. And some of those duties include signing and approving board meeting minutes, signing off on warrants, and submitting their annual statements to PERAC. Next slide, please. So for board meeting minutes and warrants, PERAC suggests that boards adopt a policy that after board meeting minutes and warrants have been reviewed by the board authorizes the executive director or the chair to sign on behalf of the board members. The board should be sure to document everything, including the adoption of the policy and their review of each document. This is a really critical step. And in terms of warrant approval, the executive director should also ask each board member to send an email indicating their approval. Keep in mind that the board may have to vote to suspend any current regulations they have in place regarding warrant signatures or board meeting minute signatures. For example, if the board has a regulation in place requiring 2 member signatures on warrants, the board should temporarily suspend such a regulation and adopt a regulation authorizing the executive director to sign on behalf of the other board members. So PERAC, as the regulator and entity charged with approving supplemental regulations, would approve of these temporary suspensions and regulations or the adoption of a policy such as the one I just described. Alternatively, if the board wishes, they could implement the use of DocuSign for signing off on warrants and meeting minutes. I'm going to talk a bit more about DocuSign in just a minute. But first, annual statements. So the boards are required to submit signed annual statements with PERAC every year. Memo number 17 of 2020, which we just sent out, allows boards to submit their annual statements without signatures. Specifically, memo number 17 provides that boards are authorized to submit unsigned statements and subsequently to submit the minutes reflecting the board members' adoption of the statement. So PERAC, will eventually seek a traditional signed annual statement once normalcy returns. So DocuSign, we have been receiving a lot of questions about the board's use of programs like DocuSign. So what DocuSign is it's essentially an online application that provides an e-signature service. So with DocuSign, you can upload a document that needs to be signed, designate the individuals that need to sign the document, and then the designated individuals will then be prompted to open the documents on their internet-enabled device and sign the document electronically. DocuSign is a free web-based service, but it does charge for premium features like signer authentication. As I mentioned earlier, instead of adopting a policy relative to the signing of warrants and meeting minutes, boards could adopt a policy regarding the use of DocuSign, but boards really should only adopt DocuSign if the board does not have any signatories that could actually sign and provide a wet signature on documents, and if the board believes that DocuSign can be easily implemented and the board wishes to use DocuSign on a more permanent basis, not just during the pandemic, but maybe they want to continue using it after normalcy returns. So now I'm going to turn it over to our general counsel, Judith Corrigan, and she's going to talk more about signatures on member forms.
Hello, everybody. I hope you can hear me. I don't know how I'll know if you can't. I apologize that my neighbor is cutting down a tree now, so there's a lot of stuff going on in the background. I don't know if some wires came down last night. As Katie said, we've had a lot of questions about signatures and how to do them during this time. You know, during these interesting times, nobody wants to hand somebody a pen, sign it on a board, on a piece of paper, and hand it back. On Friday night, I had to take my daughter Grace to the emergency room at Children's Hospital. I haven't been to the Children's Hospital in years. Grace is 19, but she was sent there because of prior issues that they thought might be related to this. And they think she might have an ulcer. She does not have COVID-19, but we went to Children's Hospital. We were there the traditional 7 hours, which is pretty good for Children's Hospital. I couldn't identify anyone that treated us because they were all dressed like astronauts when they came into the room. It was crazy. But when we went to check out at the end and I tried to pay, the people were completely enclosed in a cage. And they said, during this time period, we're not accepting signatures. We're not touching people's credit cards. So that's where this comes from, this business of not wanting to touch things that other people have touched. So questions have arisen, particularly on slide 8, you'll see electronic signatures, beneficiary forms, and annual affidavits. And there have been questions about the acceptance of electronic signatures during this time period. And are they acceptable? The short answer is they're not acceptable, even during the state of emergency, but we've come up with different ways to try to approach this situation. Next slide, please. So this first bullet point should really say, thank you for switching slides, by the way. This next bullet point should really say, the acceptance of electronic signatures will be assessed on a form-by-form basis. And as the second bullet point says, the signature has been historically required, a wet signature has been historically been required by PERAC. And leaving Prosper aside, I believe currently the only electronic signature we are accepting are on the waiver for electronic, for that teleconference under medical panels. And Kate Hogan will talk more about that in a little while. However, I did want you to be aware that the Office of the State Treasurer has proposed legislation during this session about accepting electronic signatures. It is House Bill 50, and it provides for a task force to be assembled to study and provide recommendations regarding the use of electronic signatures on prescribed forms for benefit requests and all related benefit transactions under Chapter 32 of the general laws, including but not limited to applications for retirement allowance and pensions, return of the members' accumulated deductions, changes of beneficiaries, direct deposit accounts, address, and federal tax withholding. Next slide, please. So that's what the treasurer has decided to do, and it isn't known if that will pass through this particular session of the legislature. But I do think in the future, some forms will have a wet signature and some forms will never have a wet signature. And one thing that is tough to foresee having a wet signature on is beneficiary forms. Second bullet point explains why these forms, need to go back one. Thanks. These forms are needed the most protection because the member is no longer around to testify as to what he or she intended. We're all aware of Dowler and Crab cases where people come and say, oh, that's not so-and-so's signature. He didn't mean to do that. I could just foresee somebody saying he didn't know anything about a computer. He wouldn't be able to push a button. These forms need the most protection because the person can't be consulted to see what they wanted. So I did want to tell you that PERAC recently advised the state board that they could receive some member forms electronically or by fax so that the state could process them, but they won't complete the transaction until a wet signature was received via mail. In some cases, like an out-of-stater changing a bank account for direct deposit, they were taking additional steps to avoid fraud, like calling the individual directly. So the state board, I think, has been doing a very good job. I myself have changed my beneficiary forms twice during the pandemic. I changed my option D form and I changed my option 11-2C form. And I changed them separately because the State Board of Retirement requires a witness who is not a beneficiary. Well, like most people, I'm sheltering in place with my beneficiaries. So where do I get a witness? And I know we've had questions about how do I get somebody to witness it for the reasons I explained and the reasons Children's Hospital billing department is in a cage and won't accept a pen through the window. So I'm sheltering in place with my father and with my 3 children, and my father and my son have the same name. So I named my daughter Grace as my option D beneficiary, and I had my father sign that, and I sent that individually. And then I changed my 11-2C beneficiaries, and Grace is not an 11-2C beneficiary because, you know, there's no point really in being a 12-2D and an 11-2C beneficiary. So she signed that form. So, and I do say that I've gotten back from the State Board of Retirement the form acknowledging their receipt. So I was able to do that at my home. I guess you need a printer and you need a copy machine and you need a mailbox near your house. But for the people that don't have it, I think we're all working hard to come up with other solutions. And witness signatures are required on these forms. If I could have the next slide, please. We've had some questions about, do we have to have witness signatures now? I just want you to be aware that, yeah, we do. For beneficiary forms, we're aware of 2 cases where CRAB has said that a beneficiary form is invalid, where the forms have not been witnessed. This may happen with other forms too, although, as we have said, the dead person is not around to consult with, but if you signed another form, they could work it out with the living you. So these cases have held that the absence of a valid witness signature renders the beneficiary designation without effect. So in the case of Fritz Elliott, CRAB ruled that a deceased member's retirement account should be paid to the deceased estate and not the petitioner who was the designated beneficiary. The decision cited 2 reasons. Mr. Bedwell failed to indicate the proportion of his benefits to be paid to Ms. Fritz Elliott, and the form was not signed by a witness. These omissions are fatal, and the consequence is that the nomination of the beneficiary form is without effect. And similarly, in Carlton, CRAB determined that the petitioner could be denied payment because the beneficiary form naming the petitioner as a beneficiary was not witnessed. So this is to answer the question, can we do without witnesses during this time period? We can't. So next slide, please. And finally, lots of questions about the annual affidavit. And we are so ahead of the curve here in Massachusetts in making sure that everybody is still living who is receiving a benefit. Horror stories from other states, generally no horror stories for Massachusetts, I believe, because of this regulation. The beginning of the regulation is set out on this slide. You have to make sure that everybody receiving a benefit, not less frequently than every 2 years, has to prove that they're alive by filling out an affidavit. Now, the definition of an affidavit is a written or printed declaration or statement of facts made voluntarily and confirmed by the oath or affirmation of a party making it and taken before an officer having the authority to administer such oath. So obviously this needs to be notarized. Next slide, please. But we have 2 suggestions for that. First of all, they just passed Chapter 71 of the Acts of 2020, an act providing for virtual notarization to address the challenges related to COVID-19. I don't know how much that would affect your members or your ability to do this, but that's one thing to think about. The other methods are, there are a lot of different things like looking up obituaries, doing death notices, reading death notices, of which there have been a lot in the paper. And I think our very good friend DeLay is good on that one. Just DeLay sending out the affidavits and setting that process in motion. So that is about it for the signature part. As John said, we're kind of trying to touch all the bases, so each portion is small. But Katie and I will accept any questions you have. Let me look in the chat area. Okay, would it be legal? Okay, we have I think we have one question. Would it be legal if a member sent a copy of their valid driver's license and the administrator witnesses a form based on that after a phone call or email? Can you, Deb, could you just contact me after this and give me more of the specifics on that? I'm not sure I understand what's going on in that question. But does anybody else have a question? Or are we all set to go on to the next presentation? And I think I will now throw it to Patrick Charles, our Senior Associate General Counsel, for his rendition of the open meeting law. Patrick?
Good morning. I'm just going to cover some basics on the open meeting law and the requirements that are still necessary, as well as the executive order that the governor signed allowing for remote participation. The governor's executive order allows remote participation so that a board meeting can be entirely conducted under remote participation. And I'm sure that all of you have already held some monthly meetings this way, most likely your April meeting, and you are probably already making plans to do your May meeting that way as well. So this is just a brief overview of the executive order, how it should be implemented, and a few points to keep in mind regarding conducting a board meeting. The executive order only applies to remote participation and does not relax the normal open meeting rules and public records laws. Obviously, with many public buildings closed, posting meetings on town bulletin boards or at the retirement board is no longer necessarily possible or useful, as no public has access to those buildings anymore. So we are recommending that you do this through the websites. You still need to post the meeting 48 hours in advance. We would recommend that you post it on the board's website or on municipal websites. I know that some of the smaller boards do not have their own website, or many of them are linked to the town's website. You still need to contain everything in that notice that would normally be required, such as the date and time and a list of topics, in other words, the agenda. And you must also include on the notice now the method of participation. Next slide, please. Normally, under remote participation, a physical quorum must still exist at the meeting location. That provision of the open meeting law was suspended by the previously mentioned executive order, which is dated March 12, 2020. And that will remain in effect until the state of emergency ends or it is rescinded by the governor. One specific note, and this is a question that we've been asked in the past, the board can utilize remote participation under the governor's order, even if the board had never adopted any remote participation policy in the past. So during the state of emergency, the board can do remote participation, even if prior to they had never adopted it. All members of the public body may participate remotely without the usual quorum requirements. You must ensure that the public has access to the body's deliberations via accessible methods. Next slide, please. You must provide access to the public. If you're going to be using telephone or internet or satellite enabled audio or video conferencing, they should be given, the public should be given access to that as well. You do not need to provide the public with the same level of access necessarily. So for instance, if the board is meeting and using video for the board members to be on screen, the public does not need to be on video unless they are participating in the meeting, or if, as we'll cover in a second, if they are the subject of the executive session or a hearing or some other matter, then they should be. If public participation is part of the meeting process, then you must continue this process. You must continue with provisions to allow for them to participate. If they are required participants, as I've mentioned here, subject to a hearing or maybe a disability application that you were reviewing, the public is to be provided with the same access access as a participant, as if they were a member of the public body. This would also include, for instance, if it is a disability hearing, if the member is represented by an attorney, the attorney should also be provided access. Next slide. Oh. Executive sessions, they should still be held for the same reasons as would normally apply. And we've given trainings in the past on monthly meetings and how to conduct a board meeting. And there's an exhaustive list from the webinars that we did from the administrative trainings that we've done that has the list of all of the reasons for going into executive session. And those same reasons still apply. You still need to announce why you're going into executive session. The members of the board and anyone required to participate should use a separate call-in or video conference for the executive session. And anyone required to participate in the executive session, again, the subject of a hearing or so forth, should have the same access as the members of the board. Next slide, please. If the board is going to have an executive session, they need to put that in the meeting posting. I realize that having a separate phone or video conference for the executive session may not be necessary. If the only people attending the public meeting are the board and staff, and they can all be in the executive session, then there's no need to leave the existing meeting. Just announce that you're going into the executive session for record purposes, and then monitor the meeting to make sure no one joins the meeting while it is in progress. I'm sure that many boards simply have their monthly meeting and it's the board and it's the board staff and that's it, that there is no members of the public. And you may be discussing litigation or something where, so you didn't have any hearings or any disabilities or any member participation. Also, if you're going to go to executive session and then adjourn without conducting any further business in open session, then you can just announce that before going into exec, and you can ask everyone to leave from the public meeting. However, if you do this, if you announce in open session that you're going into exec and that you will be adjourning directly from executive session, that means that you cannot conduct business after the executive session. You have to adjourn. So if something comes up that you need to take up in open session, you cannot do that at that meeting because you have announced previously that you were going into exec and that you would not be returning to open session. Next slide, please. Oh. Even though that the meeting is being conducted remotely, some of the same rules apply to keeping minutes and also public records. So keep in mind that because you're doing remote participation, and this applies even if you were still operating under the old rules, all votes must be recorded as a roll call vote. The minute should still include the time, date of the meeting, place. Obviously, it's remote then, but members present and absent and actions taken, including a record or roll call vote, and a copy of the meeting agenda. And you should also include all legal documents used during the meeting, approval of prior meeting minutes, description of the items discussed, and all motions made and how the board acted on each motion, again with a roll call vote. So the final point I want to make is just to be very clear is that the public records law still applies and has not been suspended. The only thing that has been suspended is the participation element, the remote participation aspect. But all other rules regarding the posting of minutes, the posting of meetings, the minutes, all the agenda and everything, that still applies, and you should still conduct the meeting the same way that you would had you an in-person meeting. Take any questions if there are any. Okay, there is one question here. A quorum is or is not required. A quorum is still required. It's just that the minimum requirement used to be before the state of emergency that a quorum of people must be present physically at the board meeting. That is no longer true, but you still have to have a quorum in order for the board to conduct its business. To clarify, do all votes need to be a roll call when conducting virtual meetings? Yes, because of the remote participation aspect, all votes need to be done by roll call. Okay, I don't see any more questions, so I will pass it to the next speaker, who I actually don't know who it is.
Good morning. I am the next presenter, and it's going to tell you I'm Natasha Dunca, but that is not true. I am Kate Hogan, and I am here with Ken Hill, and we're going to talk about COVID-19 state of emergency and how that goes along with disability retirement applications. And I hope that everybody can hear me. So as we all know, that COVID-19 has impacted all of us hugely. Since the state of emergency was announced, PERAC's disability unit had to cancel appointments for March, April, and now into May. Somewhere between 120 to 170 examinations were canceled. And my disability staff has contacted all these applicants that were impacted via phone and the boards through Prosper. Next slide, please. So in order to keep the medical panel examination process moving in an attempt to decrease any COVID-19 impact, PERAC has agreed to allow for telemedical or teleconferencing of an examination to those that can do this. To go through with this examination, all parties that have the right to attend an exam must agree to the telemedical exam. Next slide, please. In order to document this agreement with all those parties, all parties must provide a waiver to PERAC. 3 waivers need to be provided to the parties that I said before had a right to attend an exam: the applicant, the retirement board, and the employer. The waivers can be filled in from our website or from an email that was provided to the retirement boards last week. They are fillable forms and they can be downloaded and signed if that's the way you want to do it, or it can be typed in. And retirement boards are to obtain the employer waiver and submit this with the board waiver as 2 separate documents, please. Next slide. This is what the forms look like. As you can see, it basically tells the, it's pretty hard to read because it's small, but once you get back to your board, you can take a look at the ones that were sent to you. But basically it says that during this COVID-19 pandemic, the executive director, John Parsons, has agreed for this office to arrange for a telemedicine exam to take place. Next slide, please. Like I said, these forms are fillable and can be emailed to me. My email address is on the form and you will be able to reach me that way. Upon receipt of all the waivers, back up, please. Thank you. I will contact the vendors and obtain the appointment information. The appointments will be scheduled in Prosper, and the boards and all parties will be able to see them there. Next slide. So what technology is needed to do this? Well, the applicant must have a computer and an email address to get and complete the waiver. The applicant must have a phone, laptop, or tablet with a camera capability in order to attend the exam. The appointment will be scheduled in Prosper, as I just mentioned, so the medical records will be available to the vendor and physician immediately. The vendor will contact the applicant prior to the exam to go through the technical process so that they get the kinks out before the actual exam occurs. Next slide, please. So what will the exam entail? The applicant will need to provide identification and show the physician at the time the exam starts. The physician will be on the screen and speaking and seeing the applicant and vice versa. The physician will have the applicant doing the same type of movements that they would at a regular examination. The physician will obtain the history from the applicant And they, as I said, they already have the medical records with them provided through Prosper. We do realize, could back up again? The physician will not have the ability to do a hands-on, but they are still required to maintain medical standards of an examination as directed by the Board of Registration in Medicine. Next slide. The physician will complete the certificate and narrative as usual and upload into Prosper. The findings will still undergo the same PERAC quality assurance review and go to the retirement board via Prosper. Of import here, if the physician for some reason doesn't feel this method of exam is sufficient for them to make a determination, they will contact me and the applicant will be rescheduled when it's deemed safe to continue in-person exams. Next. I think we went backwards. Next slide, please. Thank you. The most frequently asked question since this started that I have gotten is, what if someone does not agree to the examination, be it the applicant, the retirement board, or the employer? This is a strictly voluntary process. If any of the parties doesn't agree, the applicant will remain in the scheduling queue until it is deemed safe to have an in-person examination. I would like to ask the retirement board staff that if you know of any party that will not be providing a waiver, please let me know via my email and I will notify the applicant. Next slide. My current priority right now is to reschedule the exams that were canceled back March, April, and May. We are currently scheduling separate examinations. Once you have more and more people at an in-web conference, there becomes technological issues. So we're currently doing the separate exams just to make sure everything is going the way it should. We will also conduct record reviews during this time. However, they will only be considered as a last resort measure, and this would need discussion between PERAC and the retirement board. Contact me via email if we need to discuss individual applicants. Next slide, please. If you have any questions, please use the chat box located on your screen, and I would be happy to answer them. I do not see anything, so we will move on to the next presenter. Thank you very much.
Kate, there was one question. Can you hear me?
I'm sorry, I didn't see it.
For the purpose of medical exam waivers, is the employer the department head or the appointing authority?
I'm sorry, repeat that?
For the purpose of medical exam waivers, is the employer the department head or the appointing authority?
The employer or the department head. I think that would be a board decision which they would prefer to take. If Ken would want to chime in here, but I think that's something the board could decide.
I think that might be a case-by-case basis. I would say normally it would be department head, but if for some reason there's an appointing authority involved, perhaps you could just email it to me, Michael, and we can take a look at it and try to help you.
Another question, does the board need to vote to adopt the waiver process?
Ken?
Yes, the board does need to vote.
And if someone doesn't like the results, can they get a new appointment?
That would be handled the way that we handle the same requests now. The board could submit a request for a new medical panel with the reasons behind it. And we would respond. And again, that's a case-by-case basis as well. Anybody else?
Kate, I'd just like to throw in that even though these exams are being done via video, they are not being recorded. Okay. And one other thing is that we've been asked questions about what if it's an involuntary application for disability retirement? The reason being that if it's involuntary, there's really no way that the member will agree to this. Well, that's the way it has to be. This is a strictly voluntary process where all three of the parties involved have to agree to it. But as I said earlier, if anyone else has any further questions, please just send me an email and we'll try to get back to you. Thank you.
Thanks, Ken. There was one earlier question that perhaps Judith might want to jump in on. It says, what is an 11-2C beneficiary form?
Thank you, Natasha. I noticed that too, but I noticed it after my part was over. I'm sorry about that, Deb. An 11-2C beneficiary form is your return of accumulated deductions or the amount in your annuity account being distributed. We separated the 12-2B and the 11-2C forms in the latest form project. And so 11-2C refers to who you want to get the money in your account when you die. And of course, 12-2D refers to who you want to get a lifetime allowance. The reason I said that you can't, there's no need to put somebody as both the 11-2D and the 12-2D, because you can't, if you nominate somebody as a 12-2D beneficiary, they have to take it. And there's no need to put an 11-2C on there. But so that's why I was jiggling my beneficiary. So I hope that adequately answers the question.
Thanks, Judith.
I just see we got two more questions. From Lisa Plosky, does the board vote to do the waivers on a case-by-case basis or just in general? I think that could be part of what the board makes their determination on. Ken, thoughts?
I believe that the board would need to take a vote on a case-by-case basis.
Okay, thank you.
I mentioned, the rules are, you do not necessarily have to be present for such a vote. It could be done over the phone.
Thank you. That's very helpful. And Colleen Laughlin has a question as well. And it looks like it may be a legal question, Ken. Can you see it?
Sure. Colleen writes that the board hasn't been able to have evidentiary hearing. Does the board need to submit something to PERAC as this delays disability process? Well, our goal here is not to delay the process any more than it needs to. I'm not sure what you mean by submit something to PERAC. However, I mean, are you saying submit something saying you haven't been able to have an evidentiary hearing? And you're concerned that perhaps a medical panel is not appropriate? I'm not sure. Colleen, if you don't mind emailing me, I'll try to help answer that question a little better.
Okay, thank you very much. We'll move on to board funding, valuations, and benefit calculations with John PERAC. Thank you.
Okay, so good morning, everybody. You'll notice when I go through my slides are not the typical slides that have the bullet points and everything. The slides that I developed are just restatements of memos that we had put out, PERAC memo number 20 and PERAC memo number 22 with the appropriate text. So I'll advance the slides and I'll make my presentation along with the slides, but just bear in mind that there are no bullet points or anything on the slides. So first, with regard to benefit calculations, one of the problems our staff has, and this relates to actuarial valuations that we perform too, is our staff cannot work remotely to approve benefit calculations for two reasons. The first one is we don't have remote access to our benefit approval program, and the documents that we would need to bring home as part of the review contain personally identifiable information, so those should not be removed from the office under any circumstance. For the benefit calculations, when the whole pandemic started, we had recommended that retirement boards pay estimated retirement benefits to new retirees pending PERAC approval. And upon PERAC approval, if an adjustment needs to be made, then an adjustment is made at that point in time. And we did change some of the text on slide 36 here from the memo. The memo was issued on April 6th. So the text that we changed is, as of today, we have approved benefit calculations through mid-March. We do have some staff who are volunteering to go into the office 1 or 2 days a week to try to keep up with some of the backlog on the benefit calculations. So it's a slow process, like I said, because we can't do this remotely. So we're just trying to do the best we can to keep up as best we can. Now, with regard to actuarial valuations, for the same reason, we can't do the actuarial valuation work at home. One, we don't have access to the program, and two, the actuarial documents that we send out have personally identifiable information. Now, for those systems that use private actuaries, this is not a problem for them. They have the ability to work remotely. So there should be no problem for those systems. It's just for the systems for which PERAC is the actuary and for who we're doing valuations this year. As soon as the office opens back up and we're able to do our valuations, we'll be working on them as soon as possible, mostly for the reason that the retirement boards who are having the valuations done this year, they need to have funding schedules adopted based on the results of this valuation. One thing I want to point out is at this time, we're not sure how we're going to deal with the expected market loss in 2020 as far as the valuation goes. Okay, we're on slide 37. That's good. So a little bit of background about PERAC memo number 22. This memo is about delaying the fiscal 21 appropriation. So the background is all the county and regional retirement systems have statutory payment dates for their, back to slide 37, please. Have statutory payment dates of July 1st and January 1st. No other system has a statutory retirement date. However, all systems have approved funding schedules, and inherent within the funding schedule is an approved payment date or payment dates and an interest rate. Now, most, if not all, of the county and regional systems offer some sort of discount for an early payment. What we mean by a discount, it's an interest savings for payments that are made in full at the beginning of the fiscal year. And the discount generally refers to a savings of about 3 months worth of interest. Many other systems who are not regional systems have assumed payment dates that are early in the fiscal year, either July 1st or August 1st. And there's some concern that they may not be able to make the full appropriation when it's due. All right, next slide. So we've received several questions dealing with those two issues there. And the first one, and this is mainly for the regional or county systems, but it applies to any system who has multiple payment dates throughout the year, for example, quarterly, monthly for the first 6 months, again, July 1st, January 1st. And the question is can the municipality still receive the full discount even if they don't make the complete payment in July? And the situations that we've been asked are what happens if they pay the appropriation in full, but not until August or September, or if they pay the majority of the fiscal 21 appropriation in July and pay the balance a couple of months later. And the second question is can the municipality whose appropriation is due at the beginning of the year make a payment in full, but not for a few months later, and not be charged the interest? All right, next slide, please. So as a result of these two questions, we came up with PERAC memo number 22, and this was released on Monday, April 27th. Now, to start, the legislature passed Chapter 53 of the Acts of 2020 to provide some relief for local municipalities who were either unable to adopt a timely budget for fiscal 21, or who may be expected to experience a shortfall in revenue due to either delayed property tax receipt or reduced or lost taxes such as sales tax or meals taxes and things like that. Next slide. The statute, Chapter 32, is silent on the issue of adjusting appropriation payments with interest if they're made on a date different from the assumed payment date in the funding schedule. And this could be for a payment made earlier or later. However, since a funding schedule, as I mentioned, is determined based on an assumed payment date and an interest rate, PERAC believes that the payment should be adjusted with interest. Now, just because PERAC believes they should, doesn't mean that PERAC initiates such the calculation. It's up to each individual retirement board to determine whether they will charge or credit interest on payments made at a different time from that assumed in their funding schedule. So because of that, we believe that retirement boards do have the authority to award interest discounts and or waive interest for late payments in situations such as this. And keep in mind that any increase in the unfunded liability due to the missed interest will be accounted for when the next funding schedule is due. So if we're doing a valuation on 1/1/20, then when the next valuation is done on January 1st, 2022, any increase in unfunded liability due to the missed interest from this year will be reflected when we do that future funding schedule. Next slide, please. What the primary concern is in all of this is that the appropriation payment does get made. So we believe that the retirement board and the municipalities should work together to reach a mutually beneficial solution that's obviously beneficial to all parties involved. And the hope is that this can be done without legislation. Legislation, if it's required, is a timely process. And we believe the statute can be interpreted to allow boards to do this. Now, before I take questions from here, I do have some other questions which were not put out in any memos that were asked of us that I want to introduce. So the first question, and I've received this several times, is can we reduce the level of our fiscal 21 appropriation to the level of our fiscal 20 appropriation? And the answer is yes, the statute does allow this. For the systems who are having evaluation performed this year, you can do that as part of your funding schedule based on this valuation. All that I ask is if your intention is to reduce your fiscal 21 appropriation, just to let us know that. And however you submit the funding schedule to us. For the systems who are not having evaluation done this year, what I would request is that you have a new funding schedule approved. And mostly what I want to see is how the board intends to handle the future appropriations. So what's going to happen in fiscal 22, fiscal 23. So basically, I'm just looking to see, is the board looking for a break just for fiscal 21, or if are they looking for a break for the next few fiscal years? The second question that I've been asked is, has there been any discussion about extending the funding schedule beyond fiscal 40? And the answer to that is no, not at this time. As I mentioned, we haven't begun work on any of our evaluations as of January 1st, 2020. However, I don't think that this is going to be a problem for any such system, because the valuation as of January 1st, 2020 is based on information as of December 31st, 2019. And the asset value at that time was nice and rosy. We haven't had the problems until the beginning of fiscal 2020. So I don't believe that the valuations performed as of January 1st, 2020 will have any problems. Now, for the systems who are having the valuation done next year, one thing that I haven't done yet is to see what impact the expected market loss in 2020 would have on the actual value of assets on January 1st, 2021. Now, for the systems who use an actuarial value of assets, what they're doing is they're not fully recognizing a gain or a loss in a given year. They're smoothing that out over 5 years. So over the past 4 years, you do have other gains and losses, which would be used to offset some of the loss from 2021. So I don't know what the ultimate impact would be on an actuarial value of assets, depending upon how bad the 2020 loss ultimately is. For the systems who use the market value, unfortunately, they're going to reflect the full expected loss in 2020 all at once. So they could have a problem when it's time for the 1/1/21 valuation to be done. And the last question that I've received is, has there been any discussion about an ERI? And unfortunately, no, there's no discussion that I'm aware of. Now, at our April commission meeting, I brought these topics up to discuss with the commission. And the commission in their discussion had indicated that they felt that no option should be taken off the table that would provide help or relief in this unprecedented time. Some of the topics that they discussed include, but are not limited to, pension holidays, extending the funding schedule, like I had mentioned, in ERIs. Now, just a note of caution, just because the commission discussed this doesn't mean that any of these things will ultimately happen. Okay, now that being said, does anyone have any questions that I hadn't brought up at this time? All right, I don't see any questions, so I will turn this over to the next presenter, and it looks like it's John Parsons.
Okay, thank you. I'm going to briefly touch on three statutory requirements relative to materials that are submitted to PERAC, and because of the logistics of the pandemic have been made more difficult. The first is relative to the board's annual statement. As you know, traditionally, the annual statement is due on May 1st, and each board has the ability to seek an extension of 30 days for extenuating circumstances. That's in the statute. So while we have no ability to simply move the May 1st deadline, what we did do in memo 20 of 2020 is we granted every board an automatic extension until June 1st. It's free. You do not need to make a request to PERAC. It's been granted. At the same time, we encourage you to submit the annual statement as soon as it's ready. We realize that this is a more difficult process this year. When we put together our investment report and our annual report, we glean information from each board's annual statements. So our ability to put out our investment report for 2019 and the annual statement for 2019 is predicated on getting that information from boards. So please submit it as soon as it's ready. And unfortunately, our reports will probably be delayed as well this year, but we will get them out as soon as we can. And Judith had touched on this earlier. Please don't wait to submit your annual statement because you cannot get your board signatures. Submit it. If you want to submit it with the minutes that approved the annual statement, that would be helpful. And ultimately, we will seek a signature page from the boards once some normalcy returns to the process. But the important thing is to get it to us as soon as you're done, and we can then move on to preparing the investment report and the annual report. The second statutory provision that I want to touch on is the statement of financial interest. This is for board members. As you know, the statutory deadline for almost all filers, except for officials who file 268A forms, is May 1st. This is a situation where PERAC has no ability to change a statutory deadline. So one thing that we've done, because people are not going out to the post office, don't have access to that service necessarily because they're quarantining, we have for this year allowed board members to submit electronically. We have set up a separate email address that was sent out in information to board members at the end of last week. If you have any questions on that, please contact Tom O'Donnell or Rose Morrison here at PERAC. But we have received quite a few submissions electronically, and that's something we hope to do in the future. But for this year, we're allowing that as an alternative to mailing it in. And while we don't have the ability to move the May 1st deadline, we obviously are cognizant of the challenges that people have to submit, and we'll take that into account with our enforcement provisions. The most important thing I would say on that, if you're having trouble for whatever reason in submitting your statement of financial interest, please reach out to us. Or when Tom reaches out to you, respond. The worst thing that can happen sometimes is that we don't get any response from an individual. We don't know your situation, so we're unable to be helpful if you don't meet us halfway. So if you have administrators, if you have a board member who you believe is going to have trouble submitting, or a board member that's on today, if you're having trouble, please reach out to us so that we can take that into account. And the final thing I want to touch on briefly is education. As you know, there's an 18 credit requirement for board members, 3-year term. The pandemic has obviously taken away our ability to have live presentations. We will not have the June Macris conference this year, which is the #1 earner of educational credits. So we have taken that into account. You'll notice in memos and email blasts that we have sent out over the last 6 or 7 weeks, we have added a number of online opportunities. There's a short presentation from the PRIM executive director on market conditions and pandemic related investment advice. We added material that came out from NC PERS. This presentation today, which is sold out, will go up on our website. And so you can please, administrators, please let anyone that might not have been able to get on, let your staff and let board members know that it will be up on our website. People can view that and then submit an affidavit to Tom O'Donnell indicating that they participated. Anyone who did participate today, your name should be under the list of attendees on the right. If not, just send us an email, but there's a long list there. Just make sure that you're on it. There's a number of online opportunities that are available year-round, whether it's open meeting law with the Attorney General, the Inspector General has a procurement program up there. PERAC has a number of prior educational presentations that are on our website. So with due respect, we do believe that the opportunities are there for anyone who needs to take to earn 3 credits during this 12-month period. The opportunities are there. And that's all I have on that. I'm going to turn it over to the next speaker. Thank you. Unless there are any questions. I don't see anything in the chat box.
Okay. Hi, hope everybody can hear me. This is Bill Keefe with Sandy King. Sandy is going to be leading the next presentation, so we figured why not give her a shot at the leading and supporting role Oscar. So you're stuck with me for this one. Next slide, please. So we're just going to talk quickly about the section of Chapter 53 that allows public sector retirees to work a little extra during this emergency period. So since the governor's declared state of emergency, public sector superannuation retirees are allowed to work without regard to their normal statutory limits. It's not a carte blanche to work for the entire year of 2020. That is, unless the emergency continues on that long. But assuming that the state of emergency ends sometime in May or June or July, the period during that emergency is what public sector superannuation retirees would be allowed to work outside of the normal limits. So municipalities had made the request for the flexibility in order to address potential workforce needs, to potentially supplement their workforce. It covers all job functions. It's not just public safety or health related. Does not apply to disability retirees, and it does not allow, we got a question on this, does not allow public safety employees to work past the maximum age as an active employee. The normal process for that is still in place. Well, it would take special legislation. If you're a public safety employee and you're hitting age 65, to continue on as a full-time employee, it requires special legislation. You can't continue on. But next slide, please. So as we just kind of covered there, during the period of emergency, the earnings and the hours worked do not count against the normal statutory limits. You know, it started on March 10th with Executive Order 591, and whenever it ends, those hours and earnings during that period wouldn't count. They're excluded from the rest of the year. And there was questions about when the emergency would end, and that would be with a written declaration from the governor. So short and sweet, hopefully that covers it. If there's any questions, and if not, we'll hand it off to Sandy.
Real quick, we have one question that came in about DocuSign. Can you hear me?
Yes. This is Katie. I can probably answer the DocuSign question.
Oh, it says the board signed the annual statement using DocuSign sent via state interchange. Are they required to do a wet signature later? Also, our warrants are signed using DocuSign. Are they required to use a wet signature when things return to normal?
If the board has adopted a policy regarding the use of DocuSign, I would say that that's sufficient.
Thanks, Katie.
Hi, good morning, everybody. This is Sandy. I just want to talk a little bit about the 2019 91A forms. Next slide, please. Hopefully, you've all have seen on our website or heard that the 91A is now due by July 15th instead of the April 15th. You don't need to contact the office to request the July extension. Hopefully, you just pass it on to your members that they have until then. If you completed your statement already, they can mail it in. We usually get a lot of foot traffic this time of year, but the office is closed, so there will not be anybody there to receive them, so they can mail them in. Next slide, please. For the 91As, it's business as usual, kind of. Mail is being received and processed daily by staff. Prosper is up and running quite well. Unlike the actuarial unit, 91A can function pretty much 100% through Prosper. So everything, once the mail's coming in, it's being scanned in, and then I can work remotely and get everything processed. So board administrators can go on and see the status of their members if they've complied. Everything's in there up to date. I think as of last week, all of mail has been scanned and processed. Boards can go in and update if a member has passed away. You can upload the death certificate or an obituary and put in the date of death. Or if you want to email me any address changes, any other status changes, and I can put those in. There's no, unlike what Bill had mentioned, there's no changes in how much an accidental or an ordinary can earn or how many hours they can work. Post-retirement, 91A limits still apply. any other changes, email is the best way for members or staff to contact me. I am still checking my voicemails. Members are calling in. Everyone is getting a call back, whether by myself or other staff or wherever there's being messages left. Next slide, please. I'm just going to mention PERAC Memo 20 again. It just touches on the post-retirement, but again, this memo is for the supers. It doesn't affect the accidental disabilities. I don't know if you're getting any calls on that, but this is strictly just it expands the limitations for the supers. Next slide, please. Memo 21 went out to all the municipal offices and boards. Again, it just touches on the post-retirement restrictions. And again, I can't stress enough that the disabilities are excluded. Next slide, please. I've been getting quite a few questions. A lot of our retirees don't file taxes, or they do file with extensions. The July deadline is not an extension. It's just an additional deadline that the IRS has put out that we're also honoring. So the members don't need to file the IRS extension. As far as I know, as of this morning, that the only IRS extension is out until October. So for the 91A purposes, that July deadline is not really an extension. It's just the new deadline. If anybody has any questions, they can email me, or if there's any kind of confusion, if I'm not clarifying myself, please just reach out. Another popular question that I'm getting is, I'm only filing 2019 taxes to get the stimulus check. Do I still need to send PERAC a copy? And what if I already filled out the 91A form and mailed it? Yes, please send PERAC a copy of your 2019 taxes regardless of why you're filing, and even if you have already submitted your 91A form. A new amended 91A form does not need to be submitted. So if they sent in the form already, they want to send the taxes in later, it's going to get scanned, it'll get attached, so everything will be put together. Can I apply for and receive unemployment benefits? Yes. Unemployment benefits will not affect your public pension since they are unearned. Unemployment benefits are not part of the calculation to determine their allowable earnings because they're not earnings. Next slide. Does anybody have any questions about the 91A form or questions that your members might be having? If not, we'll go on to, I think it's Ken. Thank you.
Hi. My presentation is about having elections in this time of the pandemic. Next slide, please. As I'm sure all of you know, most boards consist of 5 members. Of those members, 2 are elected by the membership, and they serve 3-year terms. Next slide, please. 840 CMR 7.00 are the standard rules for elections. There are certain deadlines for the minimum and the maximum number of days to perform certain procedures. For example, Reg 7.03 says that notice of election must be provided no less than 90 days prior to the election. 7.04 provides that nomination papers must be made available at least 90 days prior to the election. 7.04 further says that completed nomination papers must be provided to the board at least 45 days prior to the election. And 7.13 says that in the event that a vacancy exists, boards must hold an election within 120 days of that vacancy. Next slide, please. Well, the pandemic has thrown a monkey wrench into many election timetables. Okay? Since the state of emergency was declared on March 10th, many retirement boards have been unable to safely comply with those election regulations. And PERAC has provided advice to numerous retirement boards so affected. Next slide, please. As has been mentioned, on March 23rd, PERAC issued memo number 17. It advised boards that the legislature was expected to generally address the issue of elections, but that we were not sure if it would include retirement board elections. We stated that boards should weigh the realities of gathering signatures, closed board offices, etc., prior to initiating an election. And for ongoing elections, the board may need to consider expanding deadlines within the election cycle to address current limitations. We further noted in that memo, something that we wanted to get out there as soon as possible, that board member is eligible to serve until the qualification of the member's successor. So even though the term is only for 3 years, the incumbent may continue to serve. Next slide, please. And actually, I think you had gone backwards. So next slide. Well, the legislature did address the issue of elections. Municipalities were authorized to delay elections to June 30th. The Supreme Judicial Court also said that half the number of signatures were needed to qualify for the September primary. They did not specifically address retirement board elections, however. Next slide. In general, PERAC has given the following advice: that boards affected by the pandemic should postpone their elections. Okay. Boards should notify their members and retirees via all means at their disposal. Early on in the pandemic, we recommended that boards utilize electronic means just to get the word out faster. Boards may issue an amended notice of election with specific future dates. Again, we reminded boards that the elected board member incumbent may continue to serve until the qualification of his or her successor. And for public safety reasons, PERAC has recommended that all upcoming new elections should be conducted entirely by mail. As you know, our regulations provide that elections can be conducted entirely by mail or at a polling station in person. Given the issues that have arisen public safety wise, we have recommended that you go entirely to mail elections. Okay. Specifically, several boards are at different stages of the election cycle process. Okay. The following is PERAC's advice regarding those specific scenarios. For all scenarios, however, the incumbent elected board member, particularly if they intend to run for re-election, should not participate in any discussion or vote that concerns postponing the election. Next slide, please. For upcoming elections that are still more than 90 days away, the board likely has not sent out notice of the election. In that event, the board can choose either to wait to send out notice of the election upon the lifting of the state of emergency, wherein the date of election must be at least 90 days away, or send out notice of the election now, wherein the date of election must be at least 90 days beyond May 18th, 2020, which is the date that the current shelter in place is set to expire. We note, though, that that does not appear to be a set date, and it could quite possibly be extended into the future. So we've recommended that the boards choose an election date well in excess of 90 days beyond May 18th. Regardless of when the notice of the election is sent, the board should inform the membership that the election will occur entirely by mail. Next slide. For elections where notice of election was sent, but the timeline for nominations was open as of March 10th, 2020, which is when the state of emergency was declared, the board should either notify the membership that the election is indefinitely postponed, or send the membership an amended notice of the election, wherein the date of election must be at least 90 days after May 18th. And again, we think that it should be well in excess of 90 days beyond May 18th. And for either choice, the board should alert the membership that the election will occur entirely by mail, and that the current elected board member will continue to serve until the qualification of his or her successor. Next slide, please. For elections where notice of the election was sent, but the timeline for nominations was closed as of March 10th, 2020, the board should notify the membership that the election has been postponed, and they should provide the names of the candidates and inform the membership that the election will occur entirely by mail, should the board accept PERAC's recommendation. And the board should mail the ballots to the membership at least 21 days prior to the election. And again, the incumbent will continue to serve until the qualification of his or her successor. Next slide, please. For elections where notice was sent, the timeline for nominations closed as of March 10th, 2020, and only one candidate qualified. In that instance, the board should declare said candidate to be the elected member of the board. No election shall be held, and said candidate shall take office and serve in all respects as though he or she had been elected by election. Next slide, please. Now, again, PERAC is recommending that all upcoming elections be conducted entirely by mail. There are several boards that are not used to the process of holding elections that way. They're used to having it in a polling place. The following slides are just a reminder of the process when you hold it entirely by mail. The process essentially is that all active, inactive, and retired members of the system must be sent a ballot to the last known address. The ballot must be sent at least 21 days prior to the election date. It must be accompanied with a return envelope that must include a space where the voter must sign his or her name and provide their address. This indicates that the ballot inside is from a qualified voter. Boards may choose whether or not they want to pre-stamp the return envelopes. Next slide, please. Members should not sign the ballot. To ensure that the voter cannot be identified, the board may include a second, smaller, blank inside envelope where the ballot will be placed. The ballot will be sealed inside that ballot envelope, which contains no identifying information. That is then placed inside the signed outside envelope. Upon receipt, the outside envelope is used to verify the voter and then separated from the inside envelope. On election day, all the inside envelopes are opened. Next slide, please. This is what the pre-addressed return envelope should look like. Next slide, please. And this would be the inside ballot envelope. This envelope protects the secrecy of your vote. It will be removed from the return envelope and will be mixed with other inside ballot envelopes before it is opened. No one will know how you voted. Place your completed ballot inside the envelope, seal it, and place it inside the pre-addressed return envelope for mailing. Next slide, please. Or, the size of the ballot should be such that it must be folded in order to be placed inside the identifying return envelope. This prevents anyone opening the ballot envelope from immediately identifying the voter. These envelopes should be verified when they arrive, but not opened until election day. All envelopes should be opened and ballots separated before tabulation. Next slide, please. Generally, ballots are disqualified if the ballot envelope contains no signature or address. The ballots are not returned in the envelope provided. The ballots are not able to be verified as being submitted by a member in service, an inactive member, or a retiree. The ballots of a member, inactive member, or retiree are voted more than once. The ballot was received after the deadline. The ballot contains identifying data of voter. The ballot contains a vote from more than one candidate. The ballots are defaced such that the choice of candidate is unknown. Next slide, please. And just to wrap it up, it is best practice for boards that are in this predicament to postpone their elections. And for public safety reasons, PERAC recommends that all upcoming elections should be conducted entirely by mail. And keep in mind that the incumbent elected member can continue to serve until the qualification of his or her successor. And at this point, we'll take some questions if anyone has any. Feel free to email me at PERAC if you think of some questions. And as I don't see any, I believe I'll kick this back to John Parsons, but I'm not sure.
Yep, thanks, Ken. And I just want to say thank you for everybody who has logged on today or called in. As I said earlier, the presentation will go up on our website, and anyone that wasn't able to participate can access it there. As you probably know, the questions that we dealt with today and the topics came out of the survey that we conducted a couple weeks ago with administrators. So we thank you for the large participation that we had there. We had over 80 responses to the survey. So hopefully we've touched on the subjects that people had the most questions with. And if not, if you have an individual question or we didn't get to your question or answer it in the chat box, please submit it to the appropriate speaker. Thank you. I hope everybody stays safe, and next time we get together, it'll be face to face. So thanks. Have a great day. Take care.